defendant wants you to think that Brandon has it out for her. She has tried to insinuate that Brandon was involved with working with Detective Pillar for years just to get her. But what you heard was that Brandon has actually been working with law enforcement on multiple investigations, and that in fact Melanie Boudreaux is the subject of multiple investigations. So again, as the defendant sits up here and tries to portray and paint a picture for you of her innocence and sadness and family tragedy, she again misrepresents what was told to you at trial. She tells you there was no plan, but she ignores the facts and the evidence of a very obvious long plan. A plan that started when she began, this defendant, Lori Vallow, meddling in Melanie and Brandon's marriage. And when that marriage was finally ending, this defendant continued to help her niece, Melanie. She continued to aid her. And what we see in every one of these bits of evidence is a core group of people. This defendant, her brother Alex, Melanie Boudreaux, and Chad Daybell. The four of them working together. Do we need to have words, a video? No, we do not. That is why there is that jury instruction on direct and circumstantial evidence, because you look at what is going on here, and it screams to you a conspiracy by this defendant, by Melanie Boudreaux, by Alex Cox, and by Chad Daybell to kill Brandon Boudreaux. Every action you see there, the defendant would like you to look at them individually and pretend that they don't all point to what happened on October 2nd. But everything they did leading up to then shows you a way to cover up and prepare for the murder of Brandon Boudreaux. When we talk about a plan and this defendant's actions, the most obvious and screaming piece of information is this defendant holding on to her brother's phone for days, holding on to the 480-351-9120 number for days while her brother is gone, with her Jeep, without the rear tire, without the back seat, with a gun with him. That is part of the plan. That is the assisting, that is the promoting, that is the conspiracy that this defendant wants you to pretend doesn't exist. We don't need words. We have actions that are obvious, and they're done by this defendant and her co-conspirators. The state asks you to look at everything together, regardless of how many people want to cry up here, regardless of how many people want to try to testify. This is not evidence. What is evidence is what was presented to you in trial, and each piece of that tells you this defendant is guilty. And so I ask you to find her guilty of the conspiracy to commit murder against Brandon Boudreaux. Thank you.
All right, members of the jury, the case is going to be submitted to you shortly, but first we're going to draw our alternate jurors. Again, we have extra jurors just in case someone becomes sick or is unable to proceed. So we're going to call 3 alternate jurors. If you are an alternate juror, it may be disappointing to get to this stage in the trial and not be in the deliberation process, but I have in the past had to call back an alternate juror to come back in the jury room when a juror is unable to proceed. So the admonition would still apply to you until we call you and let you know that you're excused. If I don't see you again as far as an alternate, I want to thank you for participating in this process. We couldn't have done it without you. Now we're going to use our very scientific method and draw numbers out of a hat here. juror 3. You're our first alternate. We're going to draw another.
16.
16. Okay, and
7.
jurors 3, 7, and 16. 7. Okay. I'll come back and talk to you in a few moments before you go, but please, the admonition still applies. I have had to call alternates back. Again, I thank you for your service in this matter. We're going to swear in my staff, the staff that I have so far. My Jay is on vacation this week, so go ahead.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God? I do.
All right. The jury is excused at this time to begin their deliberations.
All right, jury.
All right, please be seated. The jury is no longer present. I'm going to put everyone on notice that it would be the court's intent to take a verdict within about 20 to 25 minutes of being notified that the jury has a verdict. So if you want to be present for that verdict, I would advise everyone to stay within about 20 minutes of the courthouse. In other words, in the immediate downtown area. The state has filed an allegation of aggravating circumstances back in January of 2024. One of those aggravators is essentially kind of an overlap with the finding of dangerousness. What other aggravators would the state intend on proceeding with if there were a guilty verdict?
Your Honor, we could just prove the dangerous allegation and accomplice. That would be sufficient.
Okay. Last time we discussed this issue, the defendant was requesting a probable cause hearing, but also indicated that she didn't want to have an aggravating factors hearing. So let me ask the defendant, last time you admitted aggravators, I don't know what your intent is on this time around.
I would object to aggravating. Of course, I would object to it. I asked for a 13.5 hearing on it so that those aggravators could have probable cause. If you're going to go forward with them, then I will stipulate to them.
All right. Well, the court, I don't think you're entitled to a probable cause hearing, but based on the evidence that was admitted, the court would find that there's probable cause been established that this was a dangerous offense and that there was the presence of an accomplice. I'll go ahead and prepare the instructions just in case, and then we'll see what the jury does. Please make sure that my assistant has the necessary contact information for everyone. But again, I would ask people to stay within 20 minutes of the courthouse. All right, thank you.